Private sector employers subject to the NLRB's rules are responsible for providing the NLRB and the petitioning union with a list of eligible voters ordinarily referred to as the Excelsior list. The Amalgamated Clothing Workers, a labor union, sought certification as the bargaining representative of Excelsior underwear employees. Before the secret ballot election, to determine whether the employees wanted to unionize, Excelsior mailed its employees a letter discussing the company, the union, and negative consequences Excelsior foresaw as a result of unionization. Amalgamated asked Excelsior for a list of employee names and addresses so it could respond to the letter. Excelsior refused. When the election ballots were tallied, only 35 of Excelsior's 246 employees had voted in favor of unionization. Amalgamated challenged the result because the refusal prevented them from communicating with the employees before the election. Subsequently, in 1966, the board established a requirement that 7 days after approval of an election agreement or issuance of a decision and direction of election, the employer must file an election eligibility list containing the names and home addresses of all eligible voters with the regional director, who in turn makes the list available to all parties. In 1969, the Supreme Court approved the Excelsior requirement in NLRB versus Wyman Garden Company. Under new NLRB rules, the employer must provide an expanded alphabetized voter eligibility list in electronic format. The voter list must contain full names, work locations, shifts, job classifications, and contact information, including employee home addresses, available personal email addresses, and available home and personal cell phone numbers. The list must also be provided within 2 calendar days after the finalized election details. The definition of available is quite broad and may include contact data held by individual supervisors and departments outside of HR. Therefore, the employer may want to proactively maintain comprehensive employee contact data because failure by an employer to comply with the Excelsior rule is considered to interfere with the fairness and freedom of an election. This could provide grounds for setting aside the election if proper objections are filed.